Hello everyone, you're watching Laws at a Glance on Sansad television. I am Rashika Gangwani and here I will decode and simplify the Indian laws just for you. This time we will tell you all about the Criminal Procedure Identification Bill 2022 that was passed during the budget session of 2022 in the Parliament. The Criminal Procedure Identification Bill 2022 replaces the Identification of Prisoners Act 1920. The British Era Act was the only law in India till date that allowed the police to gather basic identifiable information such as fingerprints and footprints of the detained and convicted persons. But with the advancement of technology and the need for scientific analysis of crime and criminology, the provisions of the 1920 Act were deemed insufficient. So what changes does the new legislation bring about? We take a look at some of the key provisions of the 2022 bill. The Criminal Procedure Identification Bill 2022 expands the scope of what kind of data can be collected, from whom the data can be collected, and who can authorize the collection of permitted data. Along with what was permitted in the old law, the new bill permits collection and analysis of biological samples such as blood, semen, hair, swabs, and other attributes like handwriting, signature samples, and other samples for DNA profiling. These samples can be collected from any person who is arrested or convicted. Biological samples can even be taken forcibly from any person who is arrested for any offence against women and children, or if the offence is punishable for 7 years or more. Also, a magistrate will now be empowered to permit collection of samples from any person if she or he is under preventive detention or for the purpose of aiding an investigation. In the earlier law, only the investigating officer and a magistrate were empowered to collect the permitted samples. Under the new bill, even a head warden of a prison, a head constable, along with the previously mentioned authorities are empowered to direct the collection of samples. To maintain the records, the National Crime Records Bureau will be the central agency. It will share the data with law enforcement agencies. The data collected will be retained in digital or electronic form for 75 years. Records will be destroyed in case of persons who are acquitted after all appeals or released without trial. However, in such cases, a court or magistrate may direct the retention of details after recording reasons in writing. Hope this information was valuable to you. For such more insightful details, keep watching Sansad television. Thank you.